5 seconds to go. Start. However, the family court accepted all the oral submissions of the learned counsel for the respondent without there being any evidence on record adduced by the respondent and disallowed the maintenance application qua the appellant wife, and the High Court also erroneously confirmed the said order passed by the family court. The learned counsel for the respondent, however, submitted that the appellant wife had left the matrimonial home along with the children without any justifiable reason and had failed to prove that she was unable to maintain herself. He further submitted that though the respondent has a party plot, the same having been closed, he has no source of income. According to him, the concurrent findings of facts recorded by the two courts should not be interfered by this court. At the outset, it may be noted that Section 125 of CRPC was conceived to ameliorate the agony, anguish, and financial suffering of a woman who is required to leave the matrimonial home so that some suitable arrangements could be made to enable her to sustain herself and the children, as observed by this court in Bhuvan Mohan Singh versus Meena and others. This court, in the said case, after referring to the earlier decisions, has reiterated the principle of law as to how the proceedings under Section 125 CRPC have to be dealt with by the court. It held as under proceedings under Section 125 of the Code, it must be remembered, are of a summary nature and are intended to enable destitute wives and children, the latter whether they are legitimate or illegitimate, to get maintenance in a speedy manner. A three-judge bench in Vimla versus Veeraswamy 1991 2 SCC 375 and 1991 SCC Criminal 442, while discussing about the basic purpose under Section 125 of the Code, opined that Section 125 of the Code of Criminal Procedure is meant to achieve a social purpose. The object is to prevent vagrancy and destitution. It provides a speedy remedy for the supply of food, clothing, and shelter to the deserted wife. A two-judge bench, while adverting to the dominant purpose behind Section 125 of the Code, ruled that while dealing with the ambit and scope of the provision contained in Section 125 of the Code, it has to be borne in mind that the dominant and primary object is to give social justice to the women, child, and infirm parents, etc., and to prevent destitution and vagrancy by compelling those who can support those who are unable to support themselves but have a moral claim for support. The provisions in Section 125 provide a speedy remedy to those women, children, and destitute parents who are in distress. The provisions in Section 125 are intended to achieve this special purpose. The dominant purpose behind the benevolent provisions contained in Section 125 clearly is that the wife, child, and parents should not be left in a helpless state of distress, destitution, and starvation. Stop.